Hi there, I'm Savannah Mexto with Mannor Law Group, and I'm excited to welcome you to another webinar Wednesday with esteemed elder law and estate planning attorney, Robert Manor. On today's webinar Wednesday, Bob will be talking about real estate deeds gone wrong and some of the most common and not so common mistakes when attempting to convey real estate. Now, before I pass the torch to Bob, I'd like to cover just a few housekeeping details. First, a quick disclaimer, and Bob will cover more on this later. Today's webinar will be educational. You'll definitely learn something, but you'll not receive specific legal advice. I encourage you, if you are looking for legal advice that's unique to your situation, to contact us after the webinar. Also note that today's webinar is recorded. We'll send you a replay link tomorrow that you can share with your family and friends. If you have questions during today's webinar, I encourage you to place those questions in the chat box. We will save time at the end of today's webinar to review those questions. If for some reason we don't get to your question during today's webinar, then we'll be sure to contact you after the webinar to follow up. Now, why should you listen to what the folks at Mannor Law Group have to say? First, you should note that we're a nationally recognized and respected elder law and estate planning firm. All three of our attorneys are accredited by the Veterans Administration to assist veterans with claims and appeals. Attorney Bob Manor is nationally board certified as an elder law attorney by the National Elder Law Foundation. He's one of only 19 attorneys in Michigan to achieve this designation. He's currently on the executive board of the State Bar of Michigan Elder Law and Disability Rights Section and past president of the National Academy of Elder Law Attorneys, Michigan chapter. Lastly, Mannor Law Group has been honored by readers of our local paper as the best or favorite law firm for the last 8 years in a row. Now, without further ado, I'd like to welcome Attorney Bob Manor.
All right, folks, welcome. This is kind of a fun one for me because what you'll rarely hear from us is what some of the conversations that go on in the back room. And so folks will come in and one of the things that we're often going to be looking at are the existing deeds that people have. And so when I say you don't always hear about it is because sometimes we'll take those deeds back to the back room and just kind of shake our heads because some of the deeds are written in such a way that are going to complicate matters in severe ways. And so we don't always come back out and say, oh my goodness, this deed is written very poorly. We just say, well, we should probably fix this. But back in the back room, the attorneys and the paralegals might be looking at it and saying, okay, well, boy, this deed really has lacks in a few different ways. And so we chuckle about it sometimes because people just assume that it's so simple. You know, they'll get this form out of from the title company or from the, you know, even sometimes I've heard people say they got it right from the Register of Deeds. They got this blank form and filled it out, which is a really bad idea. And it's one of those things that it's one of the easiest things to make mistakes on are those real estate deeds. So as I always say, and what Savannah already said was, hey, we're going to give some examples here, and we think that these are going to be interesting, but you're not going to want to rely specifically and try to draft your own deeds based on this. So that's our disclaimer. You should always get proper legal advice, hopefully from us, and that you're never going to want to just rely on a webinar and then you're going to now go off and start drafting all of your own deeds. So I've broken this down into a few different things. It's a bit difficult on some of this to show you exact examples because, well, we have many, and we see many examples of deeds that have gone wrong on a weekly basis, often, multiple times a week. It's not something I could, show you. Obviously, although deeds are often a matter of public record, I'm not going to take my clients' information or even potential clients that came in to see us and use them as examples. But I've recreated some of the wording and obviously changed the names and things like that on a few cases just to show you some of the things I'm thinking about. And what's interesting about deeds is that it just seems like the simplest of things, right? How could it be complicated to say, George wants to transfer the property to Sam? Okay, so why can't we just say from George to Sam? That seems like a fairly simple thing. But if you said that, we've got problems, okay? And so that's why sometimes just thinking that it's a very simple document, and it's actually it looks simple. So I will often go through that to say just because it looks simple doesn't mean it is simple. When I've trained other attorneys, I've often told them, one of the quickest way to commit malpractice is to have a mistake on a deed. My sister is a physician, and when she was in medical school, she often would say that that radiology is one of those areas where it's easy to get sued, because if you make a mistake, it's right there on the X-ray. And so I don't know if that's true or not. I actually have no idea, but I remember her saying that back when she was in medical school. And for lawyers, one of the easiest ways to really make a mistake is on deeds, because it's going to be right there in black and white. You either did it right or you did it wrong. And I'll tell you, often it's done wrong, both by attorneys and non-attorneys, mostly by non-attorneys, honestly. But there's a lot of mistakes that we see regularly. So this is the overview, thinking that it's a simple document, lack of precision. This is probably the most common thing, is that we're not using the legal terminology that we need to use to convey it in the way that we want to convey it, okay? Then thinking that you can use plain English. I have an example of that seems, if you read it, I'm going to show you the language, you're going to read it and say, hey, what's wrong with that? We know exactly what that person intended. Well, it doesn't work that way, because lawyers are lawyers and the law is the law. Some of you will remember a few years back when a particularly famous lawyer politician was quoted as saying, well, it depends on what the definition of is. And that's actually a real thing, that when we're looking at legal documents, we have to be clear on what the definition of is, or other words. And so we're thinking that you can use plain English on deeds. Using the wrong type of deed. So now we're going to get into some education about the different types of deeds and why people might want to use different types of ones. And then misgendering and fun with dower and courtesy. So we're going to deal with some of the issues that are historically that we've had to deal with in making sure that we list the gender of the person on the deed, and then also some issues that are sort of ongoing with that make it interesting with regard to spouses and how that's changed recently, both from the standpoint of who can be considered a spouse, but also on the issue of the old law of dower and courtesy. So, and then obviously we will request that if you think that there's something that we can do for you, we'd be really happy to meet with you, and Savannah will come back on and give you some instructions about how to get a hold of us and schedule an appointment with us. So getting right into it, here's my first example. So probably one of the most common things here is going to be thinking that it's just a simple document, and that, let me make sure I'm actually sharing my webcam there. There we go. Thinking that it's actually a simple document. This is the most common thing. And so we see this over and over again. People, you can get a form that says quitclaim deed or whatever. We can get a form that says warranty deed. And so people say, okay, I was looking at one, the last couple of weeks, people have sent me these deeds, and they were clearly just a form that they got. And it looks like it's pretty easy to fill out, because it says grantor, who's selling it or who's the one that's trying to convey it. You put their name, you put their address, and then it says quit claims to, and you put their information, and it says, okay, how is that difficult? Then we put the legal description, and then we sign it, and what's the problem? And so this is, and I wish we would just make those forms obsolete and just not have those forms, because almost everybody that fills out those forms without having a legal background or a title work background or something like that is going to cause some issues here. So this is the first one that I'm showing you, and it's basically again, obviously I'm changing the names and things like that. So it was a dad that was trying to add his daughter's name to the deed. First of all, don't do that, okay? Don't add your kids' names to deeds. Unless you're buying a house together and you both put in money, don't do that, number one. So first of all, my answer is that's bad, a bad decision, and I'm going to explain that a little bit later. But secondly, when you try to do it on your own, and we often will see this with parents trying to avoid probate, farmers where they're trying to convey the farm and make sure the farm stays, a lot of times farmers are multi-generational, and so they say, okay, well, my grandfather was a farmer and my mother and father were farmers, and some of the kids are farmers, and so we want to make sure that the farmland stays in with those people that are going to be the farmers. And so they just try to, and so we see this often. And so, or with farmers, we'll often see that dad that was the farmer, and now we got some kids that are farmers, and the kids are actually taking over the farm, and so they try to deed it, and then they deed it back to dad, and it goes back and forth and all of this. And I've seen this so many times where families try to do this on their own. They think this is just a simple thing, and it's not. So what's wrong with this? So this says John Q. Sample, a single man. Get back to why it says that. Address is grantor conveys and quit claims to John Q. Sample himself and Jane Q. Sample, which in this case is his daughter, collectively as grantees. How could that be wrong? I mean, so if we just kind of break that down, it's saying from dad to dad and daughter. In other words, okay, great. So now dad and daughter own that property. Why is that a problem? Well, what do you think their reasoning was? First of all, this is something that you shouldn't have done. You shouldn't have added your kids' names. It's going to cause issues with regard to taxes potentially, definitely with regard to Medicaid. If you ever get sick or need care, it's going to cause all kinds of problems with regard to protecting your assets from nursing home, things like that. And there's a bunch of other reasons not to do it, which I'll get into later. But the bottom line is, why can't you just say from dad to dad and daughter? What is this lacking? Well, how do dad and daughter own this now? What is the nature of their ownership? And so you would think you don't have to say that. It's just obviously they own it. Well, the law in Michigan, and probably in most other states, but particularly in Michigan, the law says that if you don't say how they own it, then it is presumed to be what's called tenants in common. And I'll explain what tenants in common is in a second here. So in this case, what dad was intending to do was to say, I want to make sure that this farm is going to stay out of probate. And so I'm going to add my daughter's name to it so that when I die, it'll go to my daughter, right? Does that seem like that occurred here? And the answer is no, it did not occur here. What dad did is dad said from dad to dad 50% and daughter 50%. So what's going to happen when dad dies? Dad's 50% will have to go through probate. What if daughter dies? Daughter's 50% is going to have to go through probate, even if dad survives daughter. And what if dad wants to sell this property? Can he take care of it now? Can he just, sell it? No, he has to have daughter sign off on it. So hopefully daughter is still in a good mood because once you sign that, he's lost 50% of it, okay? So people think that just by saying from dad to dad and daughter, that means that daughter will inherit it. It does not. It means daughter now owns half of it now, okay? She's not going to inherit anything because the other half is going to have to go through the will or go through probate, okay? And so that's very problematic because clearly in this case, what they had intended was that it was an attempt to avoid probate. Several problems with that. So first of all, the wording of the deed. Secondly, this is not the best way to avoid probate. There are much better ways to avoid probate, right? And so I know people don't always like going to see a lawyer and they don't want to waste money on a lawyer. I'll tell you, it's not wasting money because this person is going to end up having a lot more legal costs when dad dies because the deed was not drafted correctly. So just being silent, the law in Michigan will then assume certain language, what should have been in there, and they're going to assume what's called tenants in common. All right, so then, but basically anytime thinking that it's a simple document, we could probably have, 1,000 examples of this. The next one is lack of precision, okay? And so this one is something I thought was interesting. It's, something similar to this came in recently, and I thought it was particularly interesting, and there could be multiple examples of lack of precision. But this one was an attempt by John Q. Sample to give it to Jane Q. Jones upon John Q. Sample's death, right? And so if you read this in plain English, John Q. Sample quit claims and conveys upon his death to Jane Q. Jones, okay? Normal humans, normal people that speak English in regular English would say, okay, I understand exactly what that means, right? So if you're just talking in plain English and having a conversation, then the plain English is simply going to be that John intends for him to keep the property until his death, and upon his death, then it will be owned by Jane Q. Jones. So again, I'm imagining this is father and daughter. Here's the problem. That doesn't say that. There is no such thing as that, okay? And what I mean by that, it is that, and I will get to the questions, but there's actually a slide on the question that's currently up there, so we'll probably answer that question in just a minute here. But there is no such thing. There's no such thing where we can say convey upon death. You know, a lot of people think that they could just put a beneficiary designation on a house or a deed. You can't put a beneficiary designation. There's things that we have that it can come close to that, but this was trying to use language that most people would commonly understand. And so, you know, I look at this and I say, okay, well, this could be, you know, as a lawyer, which, and as, you know, as a judge or a title company might look at this, they could say, okay, well, what are they trying to do? Well, first of all, they could just say this is insufficient. There is no such type of deed in Michigan that you can say quit claim and convey upon death to Jane Q. Jones. There is such a thing as a life estate deed. And so a life estate deed says, I own the current interest in the property, okay? But I don't own the future interest in the property. So I'm conveying a future interest in the property upon my death. I'm conveying to Jane, but I own it now. So what if John Q. Sample wanted to sell it during his lifetime? Well, he can sell his current interest, but who's going to buy it? Because we have no idea when John Q. Sample is going to die, right? So if we say, if this is a life estate deed, which it's not worded properly, then it would be basically that John is deeding a future interest in the property that says upon my death, Jane will get it, but John still owns everything through his lifetime. And that's considered a life estate deed. And people will do these for a variety of reasons. But the idea behind this is that doesn't get us very far. You know, John still has the right to sell it, but only for his lifetime interest in it. So most people would never buy that because they could, you know, pay John money to say, yeah, I want to be able to live in that property for your lifetime, but John's lifetime might be a day, right? So who would ever buy that? But it is, there's actually actuarial tables that we can figure out what his life interest value is. And so if in fact John and Jane, if it was a life estate deed and John and Jane want to sell it, they would attribute a portion of it as John's asset, and they would attribute a portion of it as Jane's asset, and that's how they would divide up the money. And there's actually formulas and actuarial tables to figure that out. So, but it might be that. It might be that was what the intention was, or somebody could interpret it that way. It could also be that they were intending it to be something that often is referred to as a Ladybird Deed. And the idea of a Ladybird Deed is you're saying, okay, I want to convey a future interest, but I want to hold back all of the rights to the property, including the future interest. And so a Ladybird Deed is often like a contingency. It's saying, I still have the right, I'm withholding the right to sell the property and get all of the proceeds. I'm withholding the right to live there. I'm withholding the right to mortgage it. I'm withholding the right to change my mind and deed it to somebody else. But if I haven't done any of those things, then upon my death, then it would go to Jane. Okay, that's often referred to as a Ladybird Deed. Now be careful of Ladybird Deeds and lack of precision, because I will at least once a month see something that is, attempting to be a Ladybird deed, and sometimes says the word Ladybird Deed on it, and often they were drafted by an attorney, and they do not accomplish the goals of the family, or maybe it doesn't even fit the the requirements of a Ladybird Deed. And so again, the lack of precision there. We have to use legal words in deeds, and you better be sure you understand those legal deeds, which is why you really shouldn't be drafting your own deeds. It's one of the things, it's probably the most common thing that I see people try to draft their own. They decide they don't want to draft their own will, but they draft their own deeds. Oh boy, you better not drafting your own will. It's harder to screw up a will than it is to screw up a deed. It's very easy to screw up a deed. And we have in our office a check, double check, triple check on deeds before we file them, because it's so easy to move a comma, or forget a word, or things like that, and it makes a huge difference. So what is this deed? I have no idea. So I think the possibility exists that John and Jane, when they have this deed, that three things could happen. It could be completely rejected and just say there is no such, you're trying to convey an interest you're not allowed, that doesn't exist in Michigan. It could be interpreted as if it was a life estate. It could be interpreted as if it was a Ladybird Deed. Or ultimately, it wouldn't surprise me that this would be something that a title company is going to have real trouble with, because it doesn't use the correct language to convey what they want to convey. Is there a way for John to make sure that it gets to Jane upon his death without having to go through probate? Of course, there's such a deed. Often we're going to be taking a look at trusts, things like that. So, but anytime we're not using the precise legal words, that is going to create an issue. Lack of precision. I'm going to say also an example would be coming from a trust. I saw a deed recently. I don't have an example up here, but I saw a deed recently that said their intent was they were trying to take it out of a trust. So mom had a house and apparently at some point had a trust. It was many years ago, and so they tried to, what they wanted to do was take the house out of the trust and put it back in mom's name, which is fine. That's perfectly a good thing to do. The problem is mom lost the trust, didn't have a copy of it, and now we have a question. Okay, that creates an issue. So what mom wanted to do was, mom was actually trying to sell the property, and so she was selling it to a relative. And again, you shouldn't do this without title work and without going through the proper process. But what she was trying to do, the house was paid off. She thought she could just sign a deed from mom to daughter, because daughter was actually buying it from her and giving her money for the property. The property didn't have a lot of, it wasn't a very expensive property. And so that deed where she signed that was ineffective, because in fact that property, the previous deed said that it had been put into a trust. So mom's trying to deed it to her daughter when she could do it. She would just have to do it as trustee of the trust. And so we have two problems here. Number one is she tried to sign a deed that said from mom to daughter. Well, that's not going to be effective at all, because the house was actually deeded to a trust. And secondly, she had lost the trust. So now we, had to basically recreate the trust and amend the trust accordingly. But that's another example of a lack of precision. Thinking that you can use plain English. Okay, so the one earlier, was kind of an example of that, where somebody just said, I want to convey it upon my death. That seems like that would work, but it doesn't. The big thing we're going to talk about here is tenants in common versus joint tenants. So if you're silent as to the issue, so when you say from George to George and Sarah, period, then we've got a problem, because we don't know how you own it. Do you own it as what's called tenants in common, or do you own it as joint tenants? And sometimes people try to mix and match those. Joint tenants basically means that if it was from George to George and Sarah, that George and Sarah now own it. If they're not married, they would own it as tenants in common, meaning they each own half of it, because that's presumed. If you don't use either of this language, you just say from George to George and Sarah, then it would imply that it's tenants in common. That means they each own 50% of it. That means if one of them dies, that 50% will have to go through probate. So what does joint tenants mean? Well, joint tenants mean if it's from George to George and Sarah as joint tenants, it means they both own 100% of it, but they own it combined. They own it together. So neither of them can then convey away their half of it because they own it together. It also means whoever lives longest is going to get it. So it's joint tenants, and often you'll see it say joint tenants with rights of survivorship. Well, joint tenants always has rights of survivorship. That's the nature of joint tenants. Okay, so joint tenants, and then it'll say rights of survivorship, but it doesn't actually need that language anymore or ever. Joint tenants means rights of survivorship, but it's the other thing is people own as joint tenants will often see this. So mom and dad had a property, they leave it to the two kids inherit it as joint tenants with rights of survivorship. And then one of the kids wants to put their share into a trust, or they want to sell their share, or whatever it is. They can't do it because if it's joint tenants with rights of survivorship, both owners have to sign the new deed, right? Because they own it together as a whole. They own it and they're linked together. So we see this all the time, that we'll have like a cabin up north. So mom and grandpa and grandma, or mom and dad, whatever, left it to their kids, the cabin up north. All the families use this cabin. And so now the kids are getting older and they're saying, well, boy, I would love for my kids to be able to use that cabin. And so if I die, I want to pass my rights to that cabin on to, or hunting land up north would be another example. I want to pass my rights to the hunting land on to my kids, okay? You can't do that because joint tenants with rights of survivorship means that you don't have the right to convey your interest. What it's going to happen is whichever of the kids lives longest, so there could be 9 kids, and whichever of the kids lives longest, that kid is going to be able to pass that property on, that hunting land, on to their kids. So it's by chance, right? It's by whoever happens to live longest. And that's not what grandma and grandpa wanted. That's not what anybody wanted. That's not what the individual brothers and sisters want, right? That's not what anybody intends it to be typically. So we'll often have this conversation. So we've got one of the brothers and sisters, they'll come in and they'll say, yeah, we want to make sure we have our plan together, and we're going to do a will, we're going to do a trust, we're going to do whatever legal planning they're doing. And then we get to that cabin or the hunting land up north or whatever, and they say, yeah, I own this with my brothers, I own this with my brothers and sisters. And then the only way we're going to be able to deal with that is I need to get all the brothers and sisters on the phone together, and I'm going to say, okay, y'all got a problem. You got a problem in that not all of you presumably want to be able to pass on your interest. This was your inheritance. You want to be able to pass on your interest to your family, and none of you can do that. So why don't we now change it over to tenants in common, so that that you can put your interest in it into a trust. You can have, you can convey your interest to your family upon your death, all of those types of things. But you can't do that with joint tenants with rights of survivorship. People try to do it all the time. I see this, another mistake that people make is they'll have a joint tenants with rights of survivorship, and then they try to deed it to their kids. Guess what? That was ineffective. It didn't work. Okay. Ladybird deeds, I mentioned this earlier, that people will put the word Ladybird Deed on a deed, and it's fine. I sometimes will do that. I frequently will put that word on there just to have it be sort of its shorthand for the next person that looks at it to say, okay, this is probably a Ladybird Deed. And I say probably because I've seen people put Ladybird Deed, the words Ladybird Deed on it, and it definitely doesn't meet the standards of a Ladybird Deed. It's actually, Ladybird Deed references the Land Title Standards Acts, and it's just like shorthand for that. I think it's 9.1 or 9.2 Land Title Standards, but the bottom line is the deed actually should have the right language in it, and it should probably reference the Land Title Standards, and whether it says Ladybird Deed or not, that means nothing. The word Ladybird Deed is, and there's a whole story about why people call it Ladybird Deed, and it's not related to Lady Bird Johnson of all things. Most people assume that had to have been something related to that, but it's not. And so there's an article, if you want to Google it, you can find out why people call them Ladybird Deeds. But again, these are like contingency deeds to say, upon my death, I want it to transfer, but I want to have full control over it until my death. And there's a bunch of reasons to do that. There's also a bunch of reasons not to do this. I've been threatening, and I'm joking when I say threatening, but I've been threatening to write a more scholarly article, or at least to present to the lawyers of Michigan on this issue, because I think the Ladybird Deeds are frequently overused. Okay, I think that they are used for estate planning purposes in ways that are not really accomplishing the goals of the family, and often would create significant issues, particularly if somebody goes into a nursing home. A lot of people are told, oh, you got to have a Ladybird Deed because what if you go into a nursing home? In fact, many of the Ladybird Deeds I see will actually cause more problem, make it more difficult to protect that house because it's a Ladybird Deed, particularly if it's a married couple that are trying to do a Ladybird Deed. So we usually don't do a Ladybird Deed for a married couple, and there's a bunch of reasons why. Speaking of married couples, this is a particularly interesting one. So, yeah, okay, not everybody's going to consider this interesting, but as a lawyer, I consider these interesting discussions. So, we got this tenants in common, meaning you each own half. We got joint tenants, which means each of you own all of it together, but you're combined. And then married couples own it by what's called tenants of the entirety. Okay, so that's a completely different thing from tenants in common and joint tenants. So tenants in the entirety gives special protections for married couples and provides some asset protection for married couples from debts of the individual. And there's some other benefits of tenants by the entirety. What's interesting about this is that how you create tenants of the entirety. I rarely see a deed that says from seller to George and Sarah, but as tenants of the entirety. Rarely do I see that word, tenants of the entirety. In fact, the tradition and what is almost always used is we say from seller to George and Sarah, husband and wife. Now we're probably going to change that language because married couples don't have to be male and female, and so it probably is going to read something like from seller to George and Sarah, a married couple, something like that. And so, but any kind of language to indicate that they're married is going to create that tenants of the entirety. So sometimes they'll say from seller to George and Sarah, his wife. A little weird wording, but that would work. That would actually create a tenants of the entirety. It could say a married couple. It could say husband and wife. It could say, anything that indicates that George and Sarah are a married couple. Okay. But that's really important to put that language in there because sometimes we'll see from seller to George and Sarah, period. All right, now we've got a problem. It doesn't matter that they were actually married, okay? It matters what the words on that deed say. So if it says from seller to George and Sarah feel like, okay, clearly it's just gonna go to the survivor of us. If George or Sarah dies, it'll go to the survivor of them. No, it won't. Because if you just say to George and Sarah, then it's going to imply tenants in common, even if they had been married for 50 years. So again, you don't want to be writing your own deeds because this is going to create all kinds of issues. Because even if George and Sarah have been married for 50 years, it doesn't matter what the reality is. It matters what the words are on the paper. Okay. So if it just says from seller to George and Sarah, then George and Sarah each own half of it, and half of it's going to go through probate when one of them dies. Right. And that creates all kinds of issues because, we've got other family members and things like that, and plus the cost of probate and all of those things. Had another one recently that I thought was real interesting. This was one of the ones that I took back into the other room and showed it to the other attorneys and say, hey, look at this one. This is a new one. And it was where it said from seller to George and Sarah, husband and wife. And they were husband and wife in 2020 or whatever year this was that they came in. But they were not husband and wife in 1975 when that deed was signed. And so now we got a big problem because the deed says to George and Sarah, husband and wife, but they didn't get married till 1976. And so in 1975, they have this deed that says the husband and wife, they weren't actually married. So in that case, we do have a problem, okay? Because what I said earlier is it doesn't matter if you're actually married, you don't own it by tenants in entirety unless the deed specifies that. The reverse isn't necessarily true. The fact that it said husband and wife in 1975, but they weren't husband and wife until 76. Now, I don't know how a title company would interpret that one. We obviously fixed it neither of them had died yet. We fixed it. It wasn't a problem. But the bottom line is, I don't know how a title company would address that. Would they say, well, they end up married, so that's fine? Or would they say, no, because they, at the time, that deed was inaccurate. And so bottom line is, we don't want to have mistakes like that. One of the things we often will see is transferring part of the property. So I see this in twofold. So again, we see this with farmers all the time, that they have it surveyed, they might even get the legal description, and they say, okay, well, we're going to deed the house part, or we're going to deed the farm part to the son or the daughter or the son-in-law, whatever it is, right? And so the problem is, it's not just, first of all, do you have the right to make that division? And, so I always say, if we're going to do that, we got to go through the county and the locality and have them divided into two, taxable numbers. So property ID numbers. So now there's separate ID, separate taxes for each of those two properties. Once we divide it, we got to make sure everybody's on board with that. The other way that I see this is when somebody tries to transfer property in a will or a trust. So this is often, I have seen this done where it was written by an attorney, but sometimes it's where it was not written by an attorney. So I had seen ones where it said, well, the house and 1 acre go to my son, and the rest of it divided equally between my kids. Okay, that's not going to be sufficient, because house and 1 acre is not defined. We got to actually split it off and say, okay, this acre, and otherwise we've got real problems. It's going to end up in probate. We're going to have instructions from the judge, so when people are trying to transfer things through a will or a trust, often not being specific enough or transferring part of the property. Had one recently, again, this kind of goes to the plain English question, had one recently where it actually kind of goes to the married couple thing too a little bit. So mom and dad, or grandpa, let's say grandpa and grandma, left their property to their 2 kids, right? And so the 2 kids, then one of them actually lived in the property and the other one moved out of state. And then the other kid that moved out of state said, well, this doesn't make any sense. I want to deed this to your daughter, because so we get, let's say what we got on George and Andy. So mom and dad, grandpa and grandma transferred on their death the property to George and Andy. George and Andy now own this property as tenants in common, because they didn't say how they owned it. So now each of them own 50% of it. George was living in the property. Andy said, George, I want to deed my half to your daughter. Okay, so they did that. Well, now daughter thinks that she's going to get the whole property upon George's death, dad's death. That's not going to happen, because George still owns his half. Okay, so just by, you would think, okay, well, now she's added to the deed. Well, she's added to the deed in a very specific way. Okay, so that again had to be fixed. Wrong type of deed. So warranty deed. So you'll often see in our office when we're putting assets in trusts or putting a house in a trust that we use quitclaim deeds instead of a warranty deed. And there's a very clear reason why we do that, because a warranty deed warrants that you have full right to sign that deed. And this seems like a nuance, but it's actually a pretty big deal. A warranty deed means, in my view, it means that you've had title work done and you can confirm that there's no liens against the property, there are no right-of-ways or any consumer's power right-of-ways or anything like that, and that you have full right to completely convey this property. Whereas a quitclaim deed basically says, I haven't done title work, and whatever I happen to own, that's what I'm conveying, right? And so those are often used between family members, when we're putting assets into a trust, those types of things. The problem with that, of course, is if we're putting it into a trust, it kind of makes sense. Between family members, I actually recommend that folks don't do that. If they are going to add family members to it or transfer property between family members, I think we should get title work. I think we should do it as a warranty deed, because we don't want to have it turn out that George is trying to sell the property to Sam, and George, it turns out that there's an easement, there's a right of way that George actually had transferred 10 feet to his neighbor, and then when Sam tries to deal with this, turns out that Sam doesn't own what Sam thinks he owns, and that's what quitclaim deeds can do. You can sign a quitclaim deed, and you're not actually conveying things, and so they'll file the deed, but it may not be an adequate or sufficient conveyance. Fiduciary deeds, I'll see this all the time too. So we have somebody as an executor of an estate. So as a will, they're executor of the will, the personal representative of the will, or trustee under a trust. So they're the executor of the estate, and they get done, they pay the bills, they do all the stuff they're supposed to do. And again, really, you should be using an attorney to make sure that you're getting everything right and that you're not going to have any personal liability on that. If you're the executor of the estate, I strongly recommend, hopefully you use us, but basically that you use an attorney to make sure that you as the executor don't have personal liability. Well, one of the ways we do that is to do fiduciary deeds, okay? And the reason why it's fiduciary deeds instead of a quitclaim deed or a warranty deed is because you're saying, it's not my property, I'm just the person that's in charge of it. I'm just the executor of the estate. If you sign a warranty deed, you warranted that there's not any problems with this property, that there's not any other owners, that there's not any right-of-ways or easements or any of those types of things. And so people will often say, okay, well, it was mom and dad's property, I'm just going to sign a quitclaim deed or warranty deed. Really, that should be a fiduciary deed. You're saying, okay, I've done my job as a fiduciary. It's not my property that's conveying it. I'm conveying it as just the person in charge, as the executor. So those are examples there. And then this one. So this was one of the questions that we had earlier is, well, what about now? Because there's an issue this dower and courtesy. So we never actually had, and I'm not even sure if you could pronounce it courtesy or curtsy. I think it's actually curtsy, but it was never a thing in Michigan. But we often pretended it was because the law was so weird. And when I say weird, it was that basically it goes back 500 or more years where men would die and their widows would be impoverished because the men would have transferred the property to their kids, or they would have transferred it to whoever. So what back Old English law, basically, it said, look, if a man owns property and he dies, the spouse, the wife in that case, because it was very gender related, if a man owns property and dies, the wife has an interest in that property. They have a dower interest in that property. Okay, so they can't under that language, the husband couldn't basically completely disinherit his wife. So bring that forward to 2010 or whatever year you want to go to, because this just changed in the last couple of years. But in Michigan, we would usually identify the gender of somebody, whether they were male or female, and we would often, if we were waiving dower, which is a thing that you could do in Michigan deeds, if we were transferring property from a woman where the husband didn't own it, we would often waive curtsy too, which is the male version of that. Now, I think that was available in some states because they tried to make it even, so it wasn't male or female anymore. It was any spouse has an interest in their spouse's property, and so both spouses have to sign off on that. Well, there was a law change on that recently. So just to make it fun and interesting, before the law change, what happened was that there was actually a court case, and it was recently, it was probably in the last 5 years, there was a court case, and it went up the different levels of the court, and I can't remember if it went to the Michigan Supreme Court or not. I feel like it did, but it went up to the different levels of the court, and the court said, somebody was challenging it to say, well, this law can't be constitutional because, how can you have a dower but not courtesy? How can this be specific to women have this interest in their husband's property, but men don't have an interest in their wife's property? And the court said, I mean, I don't think that's exactly the words that they used in their court opinion, but that was pretty much what they said. They said, we've been doing this for a long time. We're not going to change it. Maybe the legislature will change it. Maybe the governor will change it. And that's in fact what happened. I think the court decision actually even kind of encouraged the legislature to change it, but it was in fact the legislature went and changed it and said, we're getting rid of all of this. And so there is no dower or courtesy in Michigan anymore. There was questions after the governor and the legislature changed it, whether it was legal or not, and whether or not this was actually a constitutional issue, and whether they could just change it by passing the law. And I think that's been pretty well established that, in fact, it was a binding law, so that now a woman does not have an exact interest, doesn't have an interest. So if a husband owns real estate, a woman doesn't automatically have an interest. That doesn't mean that you can completely disinherit your spouse. There's other spousal rights that are, non-gendered spousal rights that you can elect against a will, and you can have some family exemptions and spousal exemptions and things like that. But it's not specifically tied to real estate, and it's not specifically tied to either gender. Okay, so there are some rules that make it difficult for you to completely disinherit your spouse, but it's not tied to real estate, and it's not tied to gender anymore. So the question is, regarding placing gender on a deed now, how does Michigan look at it if someone doesn't want to give their gender or uses a gender that's clearly isn't their gender? And so that's a really interesting question, because, and the bottom line is you don't have to put gender on the deed anymore. I think we still do it. Typically, we don't always do it, especially if anybody objects to it. We're not going to do it. It's not required anymore, okay? It's not required to say, grantor George, a single man or a married man or whatever. We can just say grantor George. So I think we often do it just and we do it actually both genders, because it's just almost partly it's tradition, and partly there was a part of us that said, okay, but what if somebody challenges that new law, and we just want to make sure we're compliant. But certainly anybody that doesn't want to list their gender, or that could possibly be misgendered by putting it on the deed, then just leave it off. It's perfectly fine. It's legal. It's perfectly fine. We don't have to do that. And then obviously when we get to spouses now, there's not a requirement that it be that spouses have to be male and female. So now we want to, the deeds will use different language. The deeds are going to say, instead of saying husband and wife, we'll say spouses, or something like that, and that will create that tenants of the entirety. So I think that answers that question. I don't know, Savannah will tell us in a second if there's other questions, but the bottom line is this is something that, although it seems like it would have been from a long time ago that it would be specific to women having a right in their husband's property, but husbands not having a right to their wife's property. But that seems like that would have been thrown out a long time ago. It was actually just recently, I'm going to say within the last 2 years, that has gone away. And now with same-sex marriage and things like that, it also kind of makes sense that we got rid of the other, because now if we had that and we have a same-sex married couple, it'd be very difficult to draft legal documents, as the questioner points out. It's very difficult for us to have to gender people in the legal deeds anymore, and we don't have to do it anymore. So honestly, I suspect it'll probably just fall out of practice altogether. I think on our deeds that we draft in our office, we often still put it in there. It's certainly not we don't require it, we don't demand it. We often just put it in there for the time being, but I think that will probably fall out of favor also. So my last slide, so Savannah, if there's any questions, or if you have any questions, you might want to type in those questions now, and we will deal with any other questions. I got the one question regarding the placing the gender on the deed. I think we've covered that. But and so if you have a question, you might want to think about writing that in now into the little question box. But my big takeaway today is don't add your kids' names to deeds. And I don't mean to sound angry about that, but just don't do it. This is a really bad idea. We can accomplish whatever you want to accomplish by doing it right. If the property is worth something, then it's worth doing it right. I'd hate to have you see this where you're trying to preserve that farm and trying to preserve that cabin. You're trying to make sure that you pass your house on to your kids. Adding the names to the deed is the wrong way to do it. And I know that this was something that your grandmother did, and I know it's something that your parents might have done or your Aunt Susie might have done. It just doesn't work that way anymore. I'll tell you, in my own family, my grandmother did that when she was basically in the hospital, and they didn't think that she was gonna be with us much longer. An attorney went up to the hospital and they signed a deed, transferring it over to her 4 kids, and that worked. But that was 1974. Okay, my grandmother died in 1974, and so that's just not something that you can do anymore. It's going to create all kinds of issues. It's going to create gifting issues. Could create property tax issues because there might be a loss of your personal residence exemption. It's going to create all kinds of potential family conflict. It's just a really bad idea, and there's so much better ways to handle however you want to do it. We can do it the right way, using the proper type of a deed, or more likely using a trust or having it go through the will. If you've dealt with our office, you know that we tend to like trusts because they're more thorough. And by more thorough, when we can say what happens if the person you want to leave it to is deceased. We can address what happens if there's a dispute. We can address how do we make sure that the property doesn't get uncapped so they can't reassess the property. We can address make sure that things are going to go the way that you want it to. We can address, for example, let's say you have a second marriage, and we can address to make sure that that the spouse is going to be able to live there, maybe even have rights to it, maybe even have rights to the money of it, but that whatever money is left over after the spouse dies, that's going to be properly distributed to the children. Because a lot of times we'll have a married couple, they're married later in life, they might have been married 23 years, but it's a second marriage. Each spouse has their own kids. We don't want to have the spouse kicked out of the house upon the death of the homeowner, but we also don't want that spouse and their kids to inherit the value of that house. Well, we can do that. We can't do it with a deed. That's not possible. That's too complicated with the deed. But we can clearly do that with the trust and make sure that the spouse is going to have the right to live there, maybe even be able to sell it and buy a new house with those proceeds, but that ultimately that money from that house is going to go to the right set of kids, right? So the bottom line, just don't add your kids' names to deeds. It's just such a bad idea all the way around. We're running a little short on time. Otherwise, I could go on for about a half hour about why you shouldn't add your kids' names to deeds. Savannah, do we have any other questions that we want to address today?
Hi, Bob. So I do not see any other questions that have come through the chat box.
All right. So then Savannah's going to tell you, hopefully you maybe found this interesting, and she's going to tell you about how you can pass this information along and how you can schedule an appointment with our office. So go ahead and take it away.
Thanks, Bob. And thanks everyone for joining us today. As Bob mentioned, we do have an easy way for you to go ahead and get started working with our team. So you should have an email that has arrived to your inbox probably a few minutes ago, and if it's not there, it'll be there soon. And inside of the email, it'll give you instructions on how to schedule what we call an interview call with our team. So you'll be able to click a button in the email. It'll take you to a calendar, and you'll choose a day and a time that a member of our team can call you for a quick 15-minute call at the most. During this call, you'll be able to talk to our team, ask questions about our process, and just tell us about your concerns. We'll ask questions about your situation and kind of get a better idea about what it is that you're looking for. And then at that time, we can go ahead and make an appointment for you to meet with one of our attorneys. So it's a very quick process. That call is free. There's no risk. But I encourage you, if there's something that you'd like to talk about, maybe it's a deed issue, maybe it's something else, but we are here for you. So again, that email should be there for you soon, if not already. You click the button, choose the day and time, and we'll give you a call then. Thanks again for joining us today. It's always a pleasure, and we look forward to seeing you again next week.